Can you search a dresser that's 6 feet away from a person who's under arrest? Okay, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat. This question comes from an officer in Minnesota. So he says, all right, police enter a home to arrest a subject on an outstanding warrant. So far, so good. They locate the subject sitting on a bed and take him into custody without incident, placing him in handcuffs. While speaking to him about what he needs to go with him to jail, the assisting officer starts opening drawers within 6 feet of the subject and locate narcotics. The male is then moved out into the living room, pending a search warrant for the rest of the residence. The male is about to be seated on a sofa. Prior to sitting the subject down on the sofa, the officers lift up a couch cushion and locate a firearm, and he's prohibited from possessing. Would both scenarios be lawful as a search incident to arrest? This officer, again, is in Minnesota. Let's answer the question. Okay. So let's sound some ground. What is search incident to arrest, right? Let's establish some ground rules. Search incident to arrest is a recognized exception to the Fourth Amendment warrant requirement when you make a lawful arrest. And I'm actually going to read a case here. It's called State versus Judkins. It's a Court of Appeals in Minnesota case from 2016. It's unpublished, but it actually does state the law very well. It says, the search of an area around an arrestee within his immediate control, as opposed to the search of the arrestee himself. Remember, searching the arrestee is never going to be an issue. It's whether or not it's this lunge area. Rests on either of two justifications. Number one, police need to find and remove any weapons the arrestee might use to resist or to escape, or police need to prevent the arrestee from concealing or destroying evidence, right? The Chimmel Court, that's the U.S. Supreme Court, which established a search incident to arrest, say that these rationales mark the only justifications for an area search and defined the area within an arrestee's immediate control as the area from within which he might gain possession of a weapon or destructible evidence. Okay, so that is what a search incident to arrest is on an area around the person. So going back to the scenario at hand, the question is this. The person is in handcuffs. They're allegedly cooperative. The drawer is like 6 feet away. Is that area in play? Do you think that it is reasonable to presume that, or rational to believe that the person could grab a weapon from those drawers? Well, questions like how many cops are on scene? Does he have a previous history of this? Is he known to have a weapon nearby? Does he make any indications about this? In other words, the judge is going to have to make the call. I will tell you that as a baseline issue, I think the answer is no, because I just don't see it, and also my experience as a police officer, where once you put the person in handcuffs and they are not combative, they are cooperative. I just don't, and it depends. And usually, if you're going to do an arrest warrant, you have a lot of friends with you. You're not going there by yourself. You probably have several officers here. I just don't think it's going to be very persuasive to sell the court, or persuade the court, if you want to use that word, to persuade the court that this person that dresser is immediately accessible to this person at this particular time. I don't see it, but I could be wrong. I would need more facts, right? But generally speaking, I don't teach that. What I teach at Blue to Gold, just kind of make it clean, and so that the courts will back you up, is this: if the person is in handcuffs, check for tightness, double locked, and the person is cooperative, then generally speaking, they are not, and we have plenty of officers on scene, we can control him. Then this, we don't look in dresser drawers. In fact, I use the dresser drawer as an example. I think the dresser drawer is off limits. But what's funny about this is I also talk about putting him on the couch. It's almost like this officer has been to my class, but I talk about then, okay, let's say you're moving, let's say like a domestic violence suspect to the couch while you finish your paperwork. Can you sweep that couch? The answer is yes. That area is now under the person's immediate control, immediate access. They can get a weapon from the couch cushions. Now, the one thing that we would not be allowed to do is to move the person around in order to make everything accessible, right? You move them next to the kitchen drawers. Now you search the drawers. You move them next to the toilet bowl tank. Now you can search the toilet bowl tank. No. But here, was there a legitimate reason, objectively, to put him on the couch? I'm sure there was, right? You're going to get a warrant. So now that area is under his immediate control, but the dresser drawer was not. So in this case, we have a potentially, if the court agrees with me and says that, okay, looking in the drawers, even though, okay, the guy was like, I got to bring some stuff with me. Well, I got to know about that too. Like, what did he say? Hey, did he say I got to get some stuff out of my drawers? Or did he say I need to go grab my coat? Right? I mean, why are we in the guy's drawers? But if there is no reason, search instance arrest, or with implied consent to go grab his clothes, if there was no reason to be in those drawers, then we have a fruit of the poisonous tree issue. And if we have a fruit of the poisonous tree issue, everything else falls apart because we shouldn't have even be able to got a warrant, be able to receive a warrant because we should have known what was in those drawers. At the end of the day, be legit on this stuff. Have good reason for what you're doing. Don't be snooping around people's homes. If this is, I'm not saying this is what's going on here, but don't snoop around people's homes just to hopefully find evidence if either they have access or they don't. If they don't have any kind of reasonable access, then you don't get a search instance arrest. You may have something else like consent, but that's another articulation that I would need to know more facts about. Okay? Okay. I hope this has helped you get it right every single time. If you like what we're doing here at Blue to Gold, please like, subscribe, share with your friends. And until next time, my friends, you stay safe.